challenges that you might anticipate around water resources.
Great. Okay. Anything else? Anybody? Yeah.
My name's Chris. I have a 5-acre farm property, an exempt well, and I was also interested in rainwater collection.
All right.
I'd like to know more about that and the legal issues around that.
All right. Great. Thank you. Wow, those were some super educated responses. So thank you. Anybody else? We're ready to move on? Okay. Hopefully this is the most boring slide, so everything here on out will be a little more interesting. Yes.
I'm one of the interns here at the Abandonment Farm Center, and here just kind of maybe like a piece of advice for someone who doesn't either own any land or was looking to get into the field, like what would your top few points would be for that? Like not asking right now, but in terms of like your top, just some advice for people looking to get into that.
Sure. Great. And just so I don't forget it, I did put some informational sheets out on the table. There's 3 different sheets. And if there's additional information that I cover today that you want more information on, my business card is there. So please, it has all my contact information. Please email me or call me and I can get you additional information. What I had anticipated were some of these things, but maybe not all of them. So I have kind of a overarching look at what I thought might be of interest to some small farms, up and coming business owners that are needing some irrigation. And if I say something that doesn't make sense or you want more information, feel free to interrupt me and I'll do my best to answer, unless maybe later on I'm already going to touch on that. Sound good? Okay. Seems like it's not working, so you can. So water rights. I don't know if everybody knows what they are, but they are the state's way to appropriate water for beneficial use here in Washington. This is a picture of what a water right might look like. We have 2 basic statutes or codes in the state of Washington that govern our water laws. They date back all the way to 1917, which is when we enacted laws for surface waters, and then in 1945 when we enacted our laws for groundwater. Before that, it was a much more relaxed system. If somebody wanted water, say they wanted to take it out of a river, and it was 1900, they would maybe go post a notice on the closest fence or the closest tree and say, I'm going to pull out some water here from the river, and that's what they do. And if there wasn't any disagreement in the community or from a neighbor or somebody else in that area, they just go and do it. So it was a very unofficial way to do things. But as the state became more populated, more water was being put to use, and it became more of a hot ticket item that was in demand, we decided that there needed to be a way to more regularly approve people diverting or withdrawing water for beneficial use. We go here in Washington State, with a lot of the other states in the western part of the United States, by a prior appropriation law. So that basically means it's kind of like a first in time, first in right. So if, like you see in the movie, if somebody goes to a butcher shop and pulls a number, that's their place in line. That is similar to our water rights laws. The first people who have the legal right to be using that water, they get priority to use it over those that came subsequent or later on. Yeah.
Sorry, I've also been following a little bit about what's going on with the Lummi Nation and their current legalities facing the tech water rights. So I don't know if you have any.
Yeah. It's a great question. If you don't mind, I will kind of go through some of the fundamentals, and it might help to tie it all together with some of that. It's a great thing. So this is a water right. They look a little different depending on the decade or the year that they were issued. But if you have one of these attached to your land or pertinent to your land, it's going to have it should have a lot of these basic items, such as a priority date, the person who it was issued to, the water that was to be appropriated, the amounts, both in instantaneous, so generally how many gallons per minute or cubic feet per second they could withdraw or divert from the well or the river, a total amount they could divert over a whole year. So most people aren't pumping their maximum amount 24/7. So there was an annual limit as well. It specifies the purpose of the use. And for certain purposes, it will have a length of time, like for irrigation. You're only going to be irrigating during the irrigation season. There is also the specific location of where that water is going to be diverted or withdrawn, as well as very specific property on which that water can be used. And all those components all together are that water right. So if you're to put this water to use for a different purpose or on a different location or diverting it from a different place, that would be inconsistent with the water right. You can't do it. There are some other things called water right claims, which are slightly different than water rights or water right certificates. A lot of people have these appurtenant to or attached to their property. I like to try and at least alert people to the fact that there is a difference between a water right and a water right claim, because we do have a bunch of them up here in Whatcom County. And sometimes people aren't clear on what the distinction is. And legally, there's a big distinction, especially for somebody who's going to be looking to purchase a property, lease a property, try and use some water. So a water right claim is somebody's claim or assertion that they were using water before our state's water codes came to be. So they were one of those people who them or one of their family members years ago was tacking that sign to the tree before we had our water laws requiring water rights. And they were using it either before 1917 if it was a surface water body, or before 1945 if it was groundwater. And this opened up, the Claims Registration Act occurred in 1967, and people had an opportunity up until the early 70s to submit their claim and assert that they were using water that predated our water right laws. In most instances in Washington State, and in all the instances that I'm aware of in Whatcom County, these have never been reviewed, affirmed, validated in any way other than that landowner's assertion that it's fact. So when they came into the state, basically a stamp was put on it, and it was accepted as that landowner submitted it. So it may or may not represent a valid vested right to use that water. The only person that can determine that is a superior court judge, which is why it's a little bit more of a hurdle to determine if this represents a valid vested legal use to that water. The only areas pretty much in Washington where it has occurred and a superior court judge has reviewed it is in Yakima. So all of our claims up here in Whatcom County, the only way in almost all instances that the state has reviewed it is to stamp it. There's a few other times we've looked at them, but rarely. So if you're looking at property, you're going to want to evaluate maybe what this says. So this is one of our long form claims. If you look at it, it's very similar to the information that was on that certificated water right on the previous slide. It has the source of the water, the quantity, the dates it was put to use. It talks about where it's being diverted from and the land that it's being applied on and what the purpose was. There's also a question about when it was first put to use. So this claim says it's a surface water claim from the Nooksack River. The person who is submitting it said they didn't start to put it to use until 1950. So if that is all fact, that would not represent a valid vested claim to the water because it was not put to use before 1917. A lot of people didn't understand what the claims were for, so there was some confusion. There can also be sometimes confusion on, well, maybe Leslie bought this property May 1950, but his grandparents had been farming it, you know, for decades before that. So maybe it actually does represent a water use that predates the code, but the only person that can determine that is a judge. So if you're looking at property, you're going to want to look at those. Yeah.
How many claims are there for the county?
That's a great question. We have up here in WIRA 1 about 4,800. A lot. Sometimes you'll see one person, one property submitting 6 claims for the exact same property or seemingly for the exact same thing. Like I said, there was maybe some confusion in what to fill out or how. So there's multiple claims for single properties we sometimes see. Yeah.
When you have water rights and water right claims, bottom line is the state owns the water.
The state does not own the water. Part of our water, the State Department of Ecology, the water is owned by the people. The State Department of Ecology has been put in charge of making sure that the laws of the state are followed. But it's considered a public resource for the citizens of the state. We're just here to manage it on behalf of the laws that the legislature's enacted, if that makes sense. That's a great question. We'll go to the next slide. I also have a picture of a short form claim. This was the other type we had. This was for folks who were using smaller amounts of water, up to 5,000 gallons per day. And so this form was much simpler. Doesn't even ask when you began to use it or the quantities, because it was presumed that it was no more than 5,000 gallons. And so this is what a short form water right claim is. All right. So a lot of people probably would then want to know, if you've got property, you're looking at property, how do I find out if it's got a water right? If it's got a water right claim, what's there with this property? You know, a realtor might be telling you something, or the landowner might say, well, yeah, it comes with water. But if you're going to invest, you know, your life savings, you're going to invest your time and effort, hopefully you're going to want to do some research on your own and confirm what is or is not pertinent to that property that you're looking at leasing or buying. Some of my worst days are the calls that I get where people didn't ask the right questions. They were told something or maybe misunderstood something, and they have now purchased a property. They've sunk all their money into it, and they say, well, the person selling it to me said there's a well on the property, but they didn't follow up and say, well, is there the legal right to pull water out for 400 acres and irrigate all that property? I've just invested my whole family's, everything we have. And it turns out, no, there's no water right. There's a well on there, but there's not the legal right to use that water. So one way to find out, we have a publicly available resource that just came online in the last couple of years. It's called the Water Resources Explorer. I put the really long link to it up here, but the easiest thing you can do is just go to our main website, and this is also on my business card. Go to the main website and just type in Water Resources Explorer in the search engine, and it'll bring up this. It's an interactive map, and it'll do a research query of the water rights. We don't have the entire state mapped yet, but we do have all of Whatcom County and WIRA 1, where it extends beyond Whatcom County. So unless there is something that has changed in the last few weeks, this should be up to date and should be able to do a query for you. Yes?
Would you explain why we're
I sure would. Thank you. Thank you for asking. So it's one of those wonderful acronyms. So we have our states, but we also have another way that the state is broken up is by watershed. And WIRA stands for, it's WRIA, Water Resource Inventory Area. and it's literally a designation by water body. And so we here are in WIRA 1, which is the Nooksack Basin. Not WIRA 1, a little bit extends down into Skagit, but it's primarily into Whatcom County. And there are some other areas outside of WIRA 1 that are within Whatcom County. But frequently when we talk about Whatcom County, you'll also hear people, when they're talking about water, refer to the Nooksack Basin or WIRA 1. So thank you for catching me on that. I appreciate that. All right, so if you go to this resource, we can click on the next one. I was just gonna walk you through kind of how to use it. For those of you who have used any GIS, ArcGIS or anything, it's very similar to that. And we have some map tools up here, which will allow you to zoom into any portion of the state. This is set on a topo map option. There's also an aerial map. So if you just want to zoom in to an area and yourself just investigate what water rights are there, you can do that. You can also use, if you'll go back, can you go back one slide? There are a bunch of search options here where you can search by, if you know a water right number, you can search by that. If you know the parcel number, if you know the general location, if you know the name on the water right certificate, there's a bunch of different ways you can query by all of those. What'll happen is the next couple of screenshots are a query I did for the city of Linden. I wanted to see what water rights the city of Linden has. So this is what it pulled up. This is the aerial photo. It pulled up all of these water rights that have the city of Linden name on them. And if you select one, it will actually show you that place of use where that water can be used. And on the other side here, it provides you with a summary of the water right. So how much water, the purpose of it, what the source is. And then it also has hyperlinks to all the images. So if you want to take a look at that water right certificate yourself, it's right there for you to download and take a look at. You can see also there's a bunch of different properties here with different lines. Those are just designating different sorts of water rights that are in that area. So for example, if you had just zoomed in on the map, you know, you could select a property and take a look and see what that water right is that's pertinent to or attached to that property and do an investigation that way. Any questions on that? Okay. You can go to the next slide. So let's say you're taking a look. Oh, we have a question, yeah.
Does that website show the water right claims and the permit?
It does. It also shows people who've put in water right applications that have not been processed or are in the process of being processed. Thank you. Yeah, it shows all of our water right documents. But you can, there's actually options to set it to just show certain ones as well. So you can limit what you're looking at. And had a question?
Comprehensive of everything that's out there, and as far as water rights, water claims, it's everything that flows.
It should be for Whatcom County and the Nooksack Basin. I think we've got about 60% of the state mapped currently. It's a very slow process. So we're fortunate up here in that we are done, and they are keeping up to speed on any new water rights or changes to water rights or applications that come in. So it should be relatively up to date, but other parts of the state, you'd want to check ahead of time and confirm that it's got all the data. Yeah. Exempt wells are, there's no, there's no images like water rights certificates and papers that would show that. This is, this relates back to the information on the water right document. So, and we can talk about exempt wells later, but no, that would not be on there. And I thought I saw another question earlier. Yeah.
So just to clarify, the water right is attached to a piece of property and transfers to the sale. It's not like attached to the owner of the property.
Yeah, that's a great question. And it gets a little tricky. So water rights are basically in 3 stages. The first stage is when somebody applies for it and you have a water right application. That's considered personal property of the person that put that application in. If that application moves forward and it is processed, it gets to a stage called a permit stage where they're in the development stage. Basically, if you want to do a farm, you're building out that farm and you're beginning to construct your irrigation equipment and starting to put the water to use. At that stage, it's still also that personal property of that applicant. But once it reaches the final certificate stage, that water has been put to use, the state's confirmed that, and you get a water rights certificate, then yes, it becomes attached to the property, and it'll have that original applicant's name on it, but a different person can own that property, and we don't update the name. So for one of those previous claims, we saw the name Bodie as an owner. That'll remain Bodie regardless of the property selling. The one caveat to that is that it automatically stays with the sale of the property, and I'm not a land use attorney or realtor, unless it is specifically excluded or excluded from the sale. So somebody could sell you the property, but they would say this water right is not a part of that sale. It becomes a property title right once it becomes certificated. Yeah.
Can you sell that water right individually? Like you're saying, you want to sell the property, but you keep that water right off of it, could you then sell that water right?
Potentially. The issue would then become, well, if somebody else owns the property and it's from a well that's in the center of that property, can you still access it? Or, if it's from a river that flows through that property, do you still have access to that diversion or withdrawal point? So technically, yes, but there would be some things you'd want to consider in doing that.
It's got to be used too, right? The water got to be used.
It does, thank you. And I was going to talk about that in a little bit, but let's talk about it now. So at the beginning, I talked about that it's a prior appropriation, first come, first serve, kind of the butcher example. There is what people like to refer to as a use it or lose it clause, a relinquishment statute that came into effect in 1967. And it says, without just cause, and there are, I believe, about 26 definitions of what just cause are, that water needs to be put to use consistent with the attributes of that water right at least once every 5 years. So, and if it is not, it can be relinquished or abandoned back to the state, because the goal is to reappropriate it to somebody that can use it, and so that it is consistently beneficially used. So some of the reasons for just cause, for example, are if you're going off into the military and you're deployed, that is one. If your source is a stream and it dries up, you can't use it. So those are some of the reasons for sufficient cause or just cause for non-use. But just not using it is not one of them. Yeah. Huh.
And the once every 5 years, that is like using to the full maximum of your water right? Is that correct?
So abandonment or relinquishment can occur in part or in whole. You guys have great questions. So yes, somebody could go and get a certificate of water right for a certain amount, and then for 10 years they are only using half of it. If they are only using half of it for a reason not consistent with the just cause for non-use, then a portion of it could revert back to the state. And so that's an important thing, and I'll get to you in a second, Eric. That's an important thing to consider also when you are taking a look at property for leasing or purchasing, taking a look at what it says on the paper, and then also finding out and doing some research on the ground, what's happening. Because just just because it's on a piece of paper doesn't mean it still exists today. So if there's a water right for irrigation, you're looking at a property that looks like it's got a mature forest that's been there for 50 years, you might want to dig a little deeper. Because yeah, maybe that water right isn't legally there, even though there's a piece of paper that said there was a certificated water right in 1947. So yes, great question and important to do the research. And Eric.
Hey, Kasey, several farmers have expressed concern about relinquishment. For example, they have certain water right, certain acreage. They improve the efficiency of the irrigation, either scheduling or better equipment, so they're using less water, and they're worried about losing the right to that unused water. My question, Kasey, is whether that has ever happened in Whatcom County or even in the state. Does ecology come in action, take away the water?
So I can speak for my tenure at Ecology and my knowledge here. There have been some examples. I would say most of the ones that I'm aware of generally occur when we are dealing with people's water rights in terms of changing them or certificating them. And I'll talk about water right changes a little bit more later, but we can only change the amount that has been beneficially used and that can be proven to have been beneficially used. So if they change their water right, the only part that we can legally change may be a portion of what is on the paper, what originally was certificated. Yeah.
So a 1.5-10 acre farm goes up for sale. We buy it, and there's a well in it. It's a working well. It's in the home. Maybe for some agricultural use, but there is no water rights at that place. That well is what? Is it still? Is the owner able to use it, or are you saying that they're going to lose?
Well, it depends on the specifics. There's a couple options that we're going to go into here, and I hope to answer that. And if I don't answer that, come back and let me know. I need to give you some more information. If you'll hold on for just a few minutes. Yeah. Do we have all the questions for so far? You guys are doing great.
One question I have is, you want to go buy a piece of property, it's got a irrigation well on it, people have been farming it, but you have no idea what happened 10 to 30 years ago.
Right.
How does DOE evaluate that? And my guess is we don't also make records to you every year telling you what we irrigate with. So how do farmers and how does DOE figure that out?
That's a great question. So we generally don't get involved with the water right just as a day-to-day course of action. If you're just buying and selling the property, we wouldn't get involved. If there is a reason for us to become involved with the water right, that is when we would want you to provide us, with proof of use once every 5 years, dating back to our relinquishment laws. So that's when it would come into effect. As somebody who's a prospective leaser, leasee, purchaser, things you can do, and we encourage folks to do when they're looking at property, reach out to the conservation district, your local conservation district. It's Hannigan and Pole Road. They're a great resource, and they can provide you generally with aerial photos of the area. You can tell back many, many decades if properties have been irrigated. There you go. So if you got one of those every 5 years, looks pretty good. You can get personal accounts from the property owners or neighbors, people that have been in that area, get somebody to attest to the fact that they've been farming it for 40 years, growing these crops, lay it all out for you and have that as a part of your record. Even if you're not doing anything with your water right, but you're purchasing the land, that's a nice thing to have just in your records. So you know the history of that water and you feel comfortable that it is a valid, legal water source for you. Hi, Bert, yeah.
What about the case where you have a surface water certificate, and then the landowner chooses to drill a well and use well water instead?
So if you are changing any component of that water right, you need to go through a water right change. And I'll talk about that in just a second, if that's all right. Okay. Okay. So, well, that gets into our question of, if you look at your property and you've got nothing there, but for whatever reason, this is the property that you really, really, really want, you know, the question I generally get from folks is, well, then why don't I just apply for and get a new water right, right? That would be easy and the way to go. And I would love to say that, yes, we can do that. But it tends to be a little bit more complicated than that. A little bit. So in 1985, we had a law come into effect that provided and set minimum in-stream flows in the Nooksack Basin. So it is similar to, it's not a water right, but it has a priority date similar to a water right. And it functions in some ways similar to a water right in that anybody who's using water thereafter can't impact those minimum flows that have been set. So in most cases in Whatcom County, actually I might even have you go back one. We have minimum flows that were set. These are all the surface water bodies, and not only flows themselves, but a status to new appropriation. The red, which kind of looks like magenta over here, those areas are all closed. So any surface water with red and anything funneling into it, if it doesn't have a color, that is also closed. There's seasonal closures in yellow, and generally that season is the irrigation season. And then green, which is basically the main stem of the Nooksack River, those have minimum flows. And so new appropriations can technically occur if the flows are above the minimum amounts, but they have to be curtailed anytime it drops below. So that's for the surface water. Because of court decisions, expansion of knowledge of the hydrology up here, that also includes any and all groundwaters that are connected to those surface waters, even by one drop. So we are very limited in our ability to appropriate new water rights up here, subsequent to 1985, subsequent to this minimum in-stream flow rule. So a lot of the things that we recommend folks do, unless they're in a very specific area and are able to get a new water right, is there's a couple options that I included here. So we'll go to the next one. And one of those, what's come up a couple times already, which is a water right change or transfer. So we talked about how each of the water rights have these components, including a place of use, a point of withdrawal or point of diversion, purpose. Those can be changed. However, there are some limits. One, you have to be able to prove that that water has been put to beneficial use at least once every 5 years, dating back to 1967. It has to be from the same body of groundwater or surface water that the existing water right is in. So if somebody had a water right up in Linden, they couldn't then go across the river down to Bellingham and transfer it there. It has to be the same body of water. And for surface waters, generally we can change it downstream, but not upstream, because you're impacting that stream negatively, generally, if you're transferring it upstream. But that is a way, if you know of somebody who has gone to, let's say they used to use Big Gun to grow corn, and now they're switching to berries and they're using a much more efficient drip irrigation system than that Big Gun, and they don't need all their water right, they can maybe transfer a portion to you, and you can get a portion of that water right, and you can both be operating under that water right. So that's what we see a lot happening. up here, and that's a great way to get legal water to your farm.
Is it possible, Kasey, to find out what people are paying for that? Listed publicly?
It's great. I would love that information. I think it's pretty similar to real estate in that it depends on the geography. So it depends where in the state you're at and what the demand is for it. I don't know the answer. And I expect it would be different in Nooksack up here in Wyra One in Whatcom County than it would be in Walla Walla. So we do have some instances in the state where the state has purchased surface water rights and to retire them and either put them back in the stream to supplement flows or for some other purposes. I don't know the value of that, but that still may be different because it's another part of the state. We don't have any of that up here yet. I actually had a realtor asking me about that, I think, earlier this week. So if you find out, please let me know. I'd love to know. Oh.
One way to kind of get an idea on that, particularly in Whatcom County, if you're talking about irrigation water rights, is to do a little research and find out how much land is going for without water rights, and how much is being sold for with water rights. And that gives you at least a rough idea of what probably the water is. And that's something you might be able to dig out.
We have another question? Okay. All right. So moving on from water right changes and transfers, another option came up at the beginning. One option is rooftop collection. So you do not need a water right to collect the rainwater that falls on any rooftop on your property if you're collecting it and putting it to use there on that property. If the roof or whatever is collecting the rain was designed for another purpose. So, I sure will. I'd love to. So what you can do is if you've got a barn, if you've got a house, if you've got an outbuilding, any rainwater that falls on that rooftop, you can collect, store, use on site. What you cannot do is build a giant tarp across a property whose sole purpose is to collect rainwater on 5 acres and collect that water. The rainwater collection has to be the secondary purpose. That probably, hopefully that example makes it a little more clear. You don't need a water right for that. That is allowed anywhere here in Whatcom County other than the Lummi Peninsula.
I was just gonna say, has this changed recently? Because the nursery where I'm living was always complaining about how it's illegal to collect rainwater. Did it used to be, or is it because of where?
The Lummi Peninsula is, oh, not Lummi Island. Just the Lummi Peninsula within the Lummi Reservation.
She's not in. So has the rules
We used to,
improved over time?
yes, we used to not be allowed to do rainwater collection without a water right. We tried to pass that law, I think 11 times in the state legislature, and we're unsuccessful each time. So we now have a rule that you can do that, and we're not requiring people to get a water right. So that works great for hoop buildings, greenhouses, folks who have purchased or are using old dairy properties and have empty manure lagoons. You can store that water if they're lined, store that water in there. You can also get storage tanks. You see these frequently out in the San Juans. This is how people live. That's how they get a lot of their water frequently out there, is their rooftop rainwater collection. We've got a couple in the county, a couple houses that also do this. But it can be used for anything. In-home use, irrigation. Yeah, it's all fair game.
That's just for the county, not in the city.
That should be everywhere in the state of Washington other than the Lummi Peninsula.
Even for using it as in-home use in the city of Bellingham?
I don't know what building codes are for health requirements for that. I believe there's at least one home in Bellingham that captures their rainwater in the Birchwood neighborhood. They're off the grid.
Yeah, you would want to check with the jurisdiction you're in.
for drinking
for
water.
drinking water, because they want people on the public system unless there's no other options, but how that exactly plays out in each jurisdiction.
I know in the county it is permitted and they have all the paperwork available actually online to do that. All right, next one. This is getting back to the question we had on wells. If you purchase a 1.5, 10 acre property and there's a well on it. And this also came up at the very beginning. Somebody mentioned something called the groundwater permit exemption, sometimes called permit exempt wells or exempt wells. So these things, if you're not familiar with it, they're codified under RCW 9044-050. And that is a law that says that you can pull out a de minimis amount of groundwater and not get a water right. So they define 4 purposes for you to do this. One is for up to 5,000 gallons a day for domestic purposes. One is for a ½ acre of non-commercial lawn or garden, so your private yard or your private garden. And then if we're talking about folks who are maybe looking at a small farm, there's an exemption for 5,000 gallons per day for an industrial or commercial use. And a farm is an farming, mushroom farming is the mushroom industry. Corn and silage industry. And then there is an unlimited amount that is allowed for stock water. This is just for what your stock animals need in terms of drinking and such. It's not for processing in like a dairy situation necessarily. Although these are all what I'll call stackable. So you can do all of these things without getting a water right. You could have your house, you could have your small backyard, you could have your commercial venture that you've got going out back, and you could also have a bunch of cows, and you're allowed to pull all the water that you're beneficially using for those purposes, limited to those amounts, out of that well without getting a water right. Yes.
This is very likely to be my future scenario. I'm so curious, if you were to question whether or not I was pulling too much, how were you separating those? Or would you basically just look for proof that my drip irrigation system wasn't pulling more than 5,000 gallons a day? Like how can you tell how much is going to the home garden and the house and the animals versus what's really regulated there?
So unless you've got an Olympic-sized pool in your backyard that you are flushing out on a daily basis, you're unlikely to be using more than 5,000 gallons per day for a home. That's generally a couple hundred. In terms of the backyard, we can measure that, right? In terms of the others, if it came to an actual situation for enforcement that we were concerned that you were overusing the 5,000 gallons, that would probably be based on the amount of acreage you're using, the crop that you're growing, and the irrigation method that you're using. Science is such these days that we can get really close to figuring out how much you need. And hopefully you're doing that before you start a farm, is you're figuring out what your crop duty is.
That would be the main thing, is you just have to figure out what you could get by on and how much you could grow and what kind of system you could
Right.
follow.
And for situations where there's a disagreement in terms of somebody says, no, I can be irrigating 7 acres, and the state says, I don't think so. I think 5 is the maximum that you can get based on that crop and based on the irrigation method you're using. If there's a discrepancy on that, we have ordered folks to install water meters so that they, if they truly believe that they can irrigate it and stretch that 5,000 gallons that far, we need proof to demonstrate it. Any other questions? You did not just yawn at me. Okay. I know I didn't see that. All right. Any other questions on the permit exemption? All right.
Around 45 minutes now.
All right. I'm almost done, I think. If you want to take a look, find out about the well on your property, or if there is a well, we have a well log database. Again, you can go to our general ecology site and put well log in the search engine function. It'll bring you up here. You can query by all sorts of information, name, address, parcel number, or you can just zoom in on a map. And if you find a well log, it will look something like this. And I'm sure Chuck can speak more to this, but it'll talk about the depth it was drilled to, what was found there, clay, soil, gravel, and maybe the pump test information, which might be of interest to you if you're looking to find a well that's productive enough to be able to use for your purpose. They frequently don't exist for older wells. We didn't require people to submit these until somewhat recently. So if you do have a well on your property, but there's no well log, that doesn't mean anything's wrong or it's illegal, just probably is an older one. And just so you're not confused, people sometimes see these and think that it's a legal right to the water because there's a well log, and it's not, unfortunately. People say, well, why did you let me drill my well if I can't pull the water out? And how the laws are written is that those are two different things. So you could drill a well and do that all perfectly legally. It's just the amount of water that you're pulling out of it that could be the problem, or that would need the legal water right. All right, I think. Oh, yeah.
The clarification of wells, if you don't have a well already on the property, is that DOE permitted? And I'm assuming that you can't just stick a well anywhere there's water.
So
are
we,
there properties where you're not allowed to put a well in?
you know, depending on your location, there may be setback requirements, you know, from lot lines, or if you're near a garbage dump. I mean, there's health requirements for setbacks. So you want to talk with your local jurisdiction and find out what those are. In general, most folks hire a well driller, and the local well drillers know those regulations quite well. You can see on our well log database if they have, if they're an approved well driller. And they frequently will do all the paperwork for you, submit the required paperwork, and just handle all of that. So you as a homeowner can just hire them. All right. Yeah.
So that well log database is not every well in the county.
Absolutely not.
So any sense at all of the discrepancies?
In terms of how many,
Yeah.
I do not know that. Other than that, there are a lot more wells out there than we have in the well log database. This also includes not just wells that are drilled for beneficial water withdrawals. It's also test wells. You frequently see along roads, wells for other purposes that are not just pulling water out. So those numbers can be a little misleading as well.